Clough. Dr. Clough received a BS from the University of Arizona and then a PhD in microbiology from the Medical College of Wisconsin. And if that wasn't not enough, Dr. Clough went on to get his JD from our law school. Dr. Clough has served on the faculties of the University of Illinois at Chicago College of Medicine, as well as Northwestern University Medical School. He was a postdoc fellow in the Department of Microbiology and Molecular Genetics and the Department of Pediatrics at the Harvard Medical School. As an intellectual property attorney, Dr. Clough counsels biotechnology and pharmaceutical companies on the acquisition and enforcement of intellectual property rights. Dr. Clough?
Thank you. I'd like to take the opportunity to introduce our panelists. Forgive the occasional editorial comment. We have immediately on my left Dr. Harry Ostrer, who should have been the only entity or person that had standing in this case at all. Dr. Ostrer is a medical geneticist at the Albert Einstein College of Medicine, and his work focuses on the genetic basis of common and rare disorders and the diagnostic laboratory, and translates findings into diagnostic or prognostic tests for use in the industry. He was a petitioner in the Association of Molecular Pathology and is the author of 2 books and 1 textbook on genetics. And he's received awards for his work from Rensselaer Polytechnic Institute, the March of Dimes Foundation, and he has a BS from MIT and an MD from Columbia University College of Physicians and Surgeons. John Hendricks is a partner at Reed Scardino in Austin and specializes in intellectual property litigation at the trial and appellate levels, and has represented the intellectual property interests of clients in a broad range of industries, including telecommunications, energy, petrochemicals, computer hardware, and software. He also represents clients in both domestic and international arbitrations and works on complex commercial litigation matters. He recently authored amicus briefs to the United States Supreme Court on behalf of the March of Dimes and other amici. He received his BA from Oberlin College, an MA and Doctor of Philosophy from the University of Chicago, and a JD from Harvard Law School. On my far left is Kevin Noonan, and in the interest of complete disclosure, we have been friends for 30 years. He's a partner with McDonald, Bain & Hulbert in Berghoff in Chicago, and he's a founding author of the Patent Dogs weblog, which focuses on biotechnology and pharmaceutical patent law. As those of you who have followed this blog probably know, Kevin is not shy about expressing his opinions. His law practice involves representing pharmaceutical companies, universities, and all aspects of patent prosecution, interferences, and litigation. He's filed amicus briefs with district courts, the Federal Circuit, and the U.S. Supreme Court. And in 2010, he was interviewed about gene patents on 60 Minutes. Dr. Noonan earned a BS from the City University of New York, a JD from John Marshall Law School, and a PhD in molecular biology from Princeton University. I'll give you a brief synopsis of this case now. As most of you know, in the 1990s, Myriad identified two genes called BRCA1 and BRCA2, and found that mutations in these genes correlated strongly with a predisposition to breast cancer. Doing what many biotechnology companies did at the time and continue to do, they filed patent applications on the genes themselves and fragments of the genes, as well as a cDNA. After the excuse me, after the patent issued, they developed a very viable commercial product and testing regimen for the use of these genes, and eventually Dr. Ostrer and a number of other people sued in a declaratory judgment action in the district court in New York claiming that, making the allegation that these genes were unpatentable. He won at the district court and went up to the Federal Circuit, who overturned the district court in with a 2-to-1 decision. The petitioners then petitioned for certiorari, which was granted by the Supreme Court, but then was remanded back to the Federal Circuit for reconsideration in view of their recent opinion in Mayo versus Prometheus, which basically held that laws of nature are not patentable. Once the Federal Circuit reviewed the case in view of Prometheus, they pretty much ignored Prometheus in their review. They came down with the same decision, and cert was granted. And in a decision that came down earlier in the year, in a 9-0 decision, the court held that a naturally occurring DNA segment is a product of nature and not patentable subject matter merely because it has been isolated. They did hold, however, that a cDNA, which doesn't exist in nature, was in fact patentable. I'll just throw out a few questions here to try to get this conversation going. What policy issues really drove you and your colleagues to bring this case? What was the real drive behind it?
I think the general view was that competition is a good thing and promotes innovation. And an anti-competitive situation was set up for testing for BRCA1 and 2. And we can get into the weeds of why I think there are some shortcomings with Myriad's test, although overall the quality of their test is really quite good. It's also quite expensive, and they're in fact quite famous for their $4,000 test. It can be done at significantly less cost than $4,000, but if there hadn't been an exclusive licensing agreement, or in essence an exclusive licensing agreement for BRCA1 and 2, then the case probably wouldn't have originated. And it's not just BRCA1 and 2 that are genes that have been patented. It's estimated that there are over 4,000 genes that have been patented. And there are a number of other companies whose business model is based on being a sole source provider for testing for those conditions. And that limits competition, that limits quality of testing. It creates a patchwork situation for conditions such as heritable arrhythmias with sudden cardiac death, where one would have to go to several laboratories in order to get a complete package of testing.
Mr. Hendricks, would you care to weigh in on this?
Well, I mean, Dr. Oster's got the inside story on on what generated the case, but having said that, I think that, you know, if there are implications, certainly Myriad no longer has a monopoly on testing for genetic testing for predisposition to breast cancer or ovarian cancer. And from the standpoint of the groups that I represented, including March of Dimes, Canavan Foundation, that was a significant victory, regardless of what other implications might have come out of the case. So I can't speak to the motivation, but I can speak to the fact that it seems that many of the patients' groups were animated by the fact that they viewed this as a commercialization and a monopolization of something that was actually damaging to healthcare.
You should actually drill in a bit more, though, about the experience of the Canavan Foundation, because those parents felt that they had really been betrayed.
Well, okay, so yeah, there's another set of policy issues other than the question of the cost of testing, the availability or the access of testing. Probably, you know, going back into the late 70s and 80s, the Canavan Foundation got involved because Daniel Greenberg, who I believe lives here in Chicago, their children were afflicted with this neurological disease similar to Tay-Sachs. Their children afflicted by this disease rarely live beyond the age of 2 or 3. In this case, they lived a little longer, but the fact of the matter is that during their lifetime, the Greenbergs freely gave their physician blood samples and the right to do a lot of experimentation with the tissues of their children for the purpose of discovering a genetic basis for the disease. He, in fact, in conjunction with his hospital, which was in Miami at the time, did isolate a genetic mutation that correlated with Canavans, and unbeknownst to the family, obtained a patent on the gene and its mutations. Now, interestingly, prior to this, prior to the patent, or at least the revelation of the patent, the Canavan Foundation had already begun a testing protocol which was offered for free. They sent the samples off to Baylor Medical School in Texas, who did it also for free, sent it back. But at one point, Baylor received a cease and desist letter from the doctor in his hospital based upon the fact that the doctor in the hospital had owned or had obtained a patent. Now, as you can imagine, the parents were, and other families, Canavan's families, were extremely discouraged about this, not only because of the fact that all of the testing was now going to go forward on a commercial basis, but because they had no idea, had never given permission, and this resulted in a lawsuit, but not in a lawsuit based on whether there was patentability of the gene, but instead on a lawsuit of whether or not their informed consent rights had been violated, and it was eventually held, or that their property had been converted. It was eventually held that the tissue could not be considered property for purposes of conversion, and the informed consent issue was interesting because while they were never informed about the commercialization or the patented or the patent application and process, they were informed and given the opportunity to voluntarily give freely of the blood samples. They just weren't told about the commercialization side of it. And the court held that the informed consent doctrine did not require the physician to actually disclose that portion of it. So the Greenbergs, subsequently, I believe there was a settlement on appeal. It's undisclosed, but the history there is important for another policy reason, and that is that case and 2 or 3 others have discouraged people from actually, in terms of giving blood and samples for further research, has driven a wedge between the patient population and medical research because of the suspicion that the medical researcher is using it for private gain.
But that case was also influential for leveraging Miami Children's Hospitals to enter into licensing agreements with us, for instance, at NYU at the time, as well as at other institutions. So it was an important experience, and for years we paid royalties to Miami Children's Hospital. Going back to your original question, it was an acceptable situation. In Myriad's case, they limited the possibility for competition, and we really should give Dr. Noonan the opportunity to speak as well.
I've been enjoying this. The one thing I think all of you should realize is that Laurie Andrews was instrumental in the Cavanagh disease case, and since she's here, you might as well acknowledge that. And the parallel of that case was a case a long time ago in the 80s in which somebody had, back before really molecular biology was commercialized, where somebody had given their blood samples of his hairy cell leukemia. And some of these leukemias make certain hormones. They just happen to make them as part of the disorganization of their biology. And somebody had patented that, and it was a case brought in California in an action in Trover, which is an old common law sort of a conversion sort of an action. And the court similarly ruled that the patient didn't really have standing to do that for very similar issues. Getting back to patent law and Myriad, there are two aspects of the case, and Myriad really deals only with the isolated DNA. And the interesting thing there is that I don't think, and it properly interpreted, and I realize that people can differ, that doing any of this genetic testing infringes any of the claims of the isolated DNA, and I'll tell you why. Now, there are oligonucleotide claims. We'll get to those. I'm not talking about those. But these claims are in the canonical form that were developed back in the 80s, where it was to an isolated DNA molecule that expressed and encoded a particular protein. And so if you think about erythropoietin or tissue plasminogen activator or human growth hormone, these were all genes that were isolated, or interferon, genes that were isolated so that a company could put them into a cell, grow them up in a big vat, and make lots of this to make a drug. And so it had to be a full-length gene. It had to give you the exact sequence and the right sequence, and really was limited to the actual sequence that they had discovered. If you do the sort of genetic testing that's done, you never have to isolate the gene, especially today, but even back when Myriad was doing this, you never isolate the complete gene. You may isolate fragments of it, and Dave did talk about the fragment claims, and I'll get to that in a minute, but you don't ever isolate the gene, and there's an argument whether you isolate the fragments either. Now, the interesting thing is the one other subtype of this claim are the oligonucleotide, or the small 15 or 20 base pair sequences that are used in many of the analytical techniques. And those, as it turns out, are probably not patentable, having nothing to do with 101, but having to do with novelty and obviousness. But that was something we didn't realize until much later. The problem is that the claims that Myriad would assert against Dr. Ostrer were the method claims, a method of predicting the risk that a woman would have breast cancer based on the presence of these mutations in the chromosomal DNA that was analyzed from the patient. And that was just the entire DNA, not any isolated DNA, except in the sense it was isolated from the cell. And those are a different set of claims that were invalidated, at least the claims that were challenged, were invalidated in the district court and affirmed by the Federal Circuit, and not even before the Supreme Court. And the only thing that Chris Hansen, who represented the ACLU, said in the entire argument to the Federal Circuit that I 100% agreed with, and was a reason that Judge Bryson, I think, went that way, was that he said, Judge, if you went back to your chambers and took your BRCA sequence and the canonical BRCA sequence and compared them, just merely reading them would infringe the claim. He was right, because the claim was overbroad, and those claims were facially invalidated, and properly so. However, the ACLU and PubPat made decisions about what claims they were going to challenge, and the ones that they didn't challenge are now before the district court in Utah against Myriad Genetics and Gene by Gene, and we'll see whether the effect of the case is, in fact, to get to the outcome that I think Dr. Ostrer would want, that you wouldn't have what he calls monopolization. Because if Myriad prevails on any of its claims, we're back where we started from.
From a patent standpoint, I would have to disagree that we're back where we started from. Plus, I think your synopsis of the case misses the implications for Section 101 jurisprudence.
Well, in which way?
In the way that Section 101 jurisprudence, I think, has been discussed, and was the primary vehicle for that discussion was the product of nature doctrine, or the so-called phenomena of nature doctrine, that was raised with respect to the to the sequence claims, the isolated sequence claims.
Right. But the cDNA is patent eligible.
Well, the cDNA was arguably was never a claim in the patent.
No, there was actually a claim to the cDNA.
I would disagree.
Oh, I don't disagree. It's claim 2 of the 282 patent.
The claim two references a sequence that is arguably from cDNA. That doesn't necessarily mean it was a claim. That's the reason, in fact, it was never even raised as a separate issue in district court. But the point is that, the fact of the matter is it was obviously an important decision from the standpoint of 101 jurisprudence. Following, I think, the decisions of Prometheus and Bilski, this was a corrective measure that the U.S. Supreme Court was taking, in a corrective measure to an ideology of put very sort of superficially, too much patenting.
Well, I understand that's the belief, and it's interesting. Mark, before talked about how the court in Actavis referenced all these decisions from the 30s and 40s. Back to the future, folks. We're back to that patent Supreme Court where the only patent that's valid is the one they didn't get their hands on yet. That's their philosophy. You want to talk about judicial philosophy, that's the philosophy of the majority of the court, which is why you get these 9-0 decisions. But the fact of the matter is, what I was addressing was the more important issue of, we got the policy reasons of why Dr. Ostrer brought the suit. And I think it's legitimate to say, did we get where Dr. Ostrer wanted us to get when he brought the suit? And I think that there's at least a reasonable chance the answer to that is no.
Well, I'll let Dr. Ostrer answer that question, but I would disagree with it because of some other reasons we can discuss
We
later.
can talk about it.
Well, I think it's going to hinge in this case on whether the federal district court judge in Salt Lake City grants a preliminary injunction to Myriad against the two defendants in the lawsuit, Myriad Genetics and Gene by Gene. That said, the landscape is in fact a bit more complicated in that other commercial and academic laboratories have jumped into the marketplace now, and Myriad, for whatever reason, chose not to challenge them, which I think is going to make their arguments in the Salt Lake City case difficult.
Now, you don't have to sue everybody. If somebody infringes your patents, you don't have to sue everybody all at the same time. You can pick and choose, and it happens all the time.
In fact, haven't there been, I don't know, hundreds, if not thousands of publications, academic publications, where BRCA1 and BRCA2 were used?
Oh, absolutely, because the point of the monopoly was not to go after people to stop research and all that. The point of it was to prevent people from charging patients for the test.
Right. Well, it wasn't from, I actually disagree with that. There was always an intent to charge people for the test, just not, $4,000.
Well, and that's what equivalent about price. It's hardly philosophy.
But the idea was to have a competitive marketplace, and certainly many of us disagreed with our lawyers. Not that that would come as a surprise to all of you. That the issue really wasn't about research in BRCA 1 and 2. As you've suggested, David, there are these famous 9,000 papers, and certainly, I've published some of those papers about BRCA 1 and 2 and continue to do so. We were never infringed by Myriad from publication, and I assume that they had an enlightened policy about that, because if we came up with something that infringed, well, they would have been all over us then. With regard to infringement. So they wanted research as a way of trolling the marketplace of ideas. They simply didn't want to have their monopoly for genetic testing disrupted. During the coffee break before, Kevin and John and I were having a discussion out there, and we were talking about, well, how wonderful is Myriad? And,
or not.
And the issue is compared to what? And Kevin likened the situation in Switzerland as one that was unfavorable when just the locals were doing testing and until Myriad jumped in. But that's one example. In the Netherlands, for instance, each of the local laboratories was doing their own version of BRCA 1 and 2 testing. Access to care wasn't an issue for Dutch people. The quality of care was outstanding. Much of what we know about BRCA 1 and 2 originated in the Netherlands. The antidote to the Myriad database of genetic variants is at Leiden University in the Netherlands. And this sort of free, unfettered competition that existed among the Dutch medical schools really promoted something that was quite outstanding and didn't require a monopoly.
Well, to the other side of that coin, and it's come up because Myriad, again, I'm not here to defend Myriad. As Hans Sauer has said, do you lose your patent just because you're a jerk? And I think some of the ways they've acted have been really kind of, sort of shoot yourself in the foot. For one example, all of the women in the case probably would have gone out as plaintiffs if the only thing they had done is allowed second opinion testing, because that was their argument. We can't get a second opinion. And it would have been a very simple thing for them to do, and they didn't do it. I don't know why they didn't do it, but they didn't do it. But what they did do is as they do the testing, they find more and more what are called variants of unknown significance. But as they get more and more, they figure out, well, in some cases, these are variants that are just natural population variants in people, and some are associated with cancer. They're not telling anybody about that. They decided they would keep that database proprietary. The concern is that if that becomes the model, then that's in fact what's going to happen, that you're not going to have the free flow of information, and then you're going to have not the original generation, but the second and the third and the fourth generation will be inhibited by people who keep that as a trade secret. And that's a real concern, even with the patents, because after all, Myriad's patents expire in about a year or two. Okay, so it is a concern. And that's something I think people have to address, because that is the future of genetic medicine, is figuring out these variants are. We're at the beginning of the road. We don't know this. If we incentivize people to not disclose, I think that's a worse outcome.
And so they're really, but if I can, sort of put a fine point on the difference here, there is an empirical question. Do patents on isolated genetic sequences incentivize research, or do they, in fact, impede innovation? And I mean, that's an empirical issue. Both sides were arguing. I frankly think there was more empirical basis for the view that, in fact, such patents are preemptive and do, in fact, impede research. But again, that's a policy issue that the court itself said it wasn't particularly interested in.
Right. It's interesting. I don't think that, maybe in other instances, I think of it a different way. I don't think that, especially in this area, that patents incentivize research. I think people do this research because we want to know the answer. I think patents can incentivize commercialization and translate. You have tech transfer offices in many universities and hospitals to take the basic science and translate it into a commercially useful form. I think that's what patents do. But the research will happen because we want to know. We have the ability to know for the first time in the how many hundreds of thousands of years that human beings have been on this planet. We have the ability to know what these things are. We're human beings. We're going to do that. People like Dr. Ostrer and others are going to want to find the answer. That's just human nature.
So I'd like to just build on another issue, though, with regard to Myriad's proprietary nature of genetic testing and the issue of second opinions. The way of calling variants in the United States really has been Myriad's way or no way. In Nature Genetics in 2007, there was this very influential paper that was written by Walter Bodmer, who's now the chancellor at Oxford. He's a Nobel Prize winner in immunology. And he expressed concern that there may be so-called moderate risk penetrance variants. And why is that a concern? Well, Myriad's way of calling variants is only going to tell you that you're at high risk. And you're at high risk because your mother who had this variant also developed breast cancer. Your sister who had this variant also developed breast cancer. But with these moderate penetrance variants, they may have had it, but they may not have developed breast cancer. Therefore, a woman's lifetime risk may not be the 85% that we commonly quote right now. Maybe it's 20% or it's 40%, but we're missing important information. And quite frankly, I'm concerned as well that we could be subject to a future class action lawsuit as medical geneticists in which we provided misinformation to our patients about what their genetic risks were. And of course, I'll be turning to you guys, when I'm...
No worries. Happy to help. But it's just a technical question. Are those variants ones that are actually disclosed in Myriad's patents? Or I just don't know whether they are or they aren't.
Well, there are some because they did, and they patented those as well.
Okay.
And so there are a number of mutations that they identified early on. They were a contributor to the public big database, and then around 2006 they said, "Oh, that's our trade secret."
Yeah, they stopped.
What do you do to incentivize those guys to make that information available?
Oh, that's a very good question. If I would say that if they're willing to take the bargain that they get their patent term and then it's over, then no, because at least some of this, Myriad's, what they've told me is people were misusing their database. Now, I think that...
What does
I think,
that mean?
I'm
And
not
that-
sure
and
exactly
that
what
makes
that
them
means.
worried?
I'm not sure exactly what that means. But I do think that's a question that goes beyond this case and that goes beyond even sort of the legal structure we have, because that's private property on some level, okay? It's information that they developed, and sort of like any other trade secret, what's the right of the government to come and take it? Now, the answer is there's a fellow in San Francisco.
UCSF, I was going to
Nussbaum,
mention
right?
that as well,
Yeah,
Bob Nussbaum,
Bob
right.
Nussbaum, who has said
Self-action.
it's very simple. It's actually great. It's crowdsourcing. He says to all the women who's gotten the test, send us your results. Okay, send us what mutations you have and what the diagnosis is. Not your name, and we'll recreate the database.
Yeah, so send us cross off your name, send
Right.
us your report.
Well, HIPAA, you have to cross them. But there's nothing wrong with that either, because that voluntarily the women are giving the information to Bob. That may be the way to do it. It may be inefficient, but it may be the way to do it, and may disincentivize keeping that information trade secret.
Don't you have the issue with getting back to our friend Ruben Madelon?
Yes, I
with-
was going to wonder if you. I wondered if you remembered Ruben's
Yes,
name.
I
Yeah,
do.
yeah.
Who was
we
a
actually knew
faculty
Ruben.
member at the University of Illinois in
Yes.
Chicago when
Yes.
he got
He was
started.
in the VA, wasn't he? I think.
No.
Okay, no,
No, he was in pediatrics.
Okay.
But Kevin and I were there with.
We were there.
Right.
Yeah, when this happened.
No, but again, now you're trading this information. We say it was a bad thing when you give information and stuff to Ruben and he commercializes it. And now you're recruiting people to get their results that'll go in a database that is presumably going to be used in conjunction with a diagnostic test that somebody's going to have to pay for.
Well, if we could get back to sort of the basics of the case, part of the case that they brought originally was about information, and the argument being that when you patent something as broadly as a gene sequence, you're not just patenting information that's been developed, acquired, et cetera. You are patenting some building blocks of information that is foundational to all subsequent information about it. That's the compelling argument to the U.S. Supreme Court. That's why some things are considered off limits. That's why Section 101, as opposed to Section 102 and 103, are still in business, according to the U.S. Supreme Court.
Right. Except the information isn't patented. So
Well,
if,
it's not now, but it was.
No, it wasn't. It never was. If I took a sequence from a patent and I interrogated a database of other species or other people, and I just did it in silico, I didn't actually make a molecule, it's not infringement. Simple. You don't infringe.
Well, you're using information in a different fashion than I am.
Well, that's the way actually Harry uses it.
Well,
right?
regardless of the way Harry's using it, I'm using it to mean the actual information that one gets from using basic building blocks. That's the reason chemicals are not patented.
Well, chemicals are patented all the time.
Well, no, not the foundational chemicals.
Well,
So-
carbon isn't patented. But
No, and vanadium wasn't patented, and titanium wasn't patented,
Yeah,
and those
but-
were all court cases.
But aramecium was.
And so,
Well,
I don't know that case, but I know that
Okay.
the reason the others were is because the theory behind excluding patents for those is the same theory behind excluding patents for basic genetic material, and that is that it is so basic, in fact, that everybody needs to have it in order to do their research.
I understand. Now, we have 9,000 research articles that have been patented, so clearly that's not a problem. Here's my problem with the
Well,
philosophy.
it is a problem. Just because you got 9,000 articles doesn't vouch for the quality of those things.
Oh, I don't know. They're peer-reviewed. I don't think they're probably pretty high quality. But
How many of
here's
those did you
the,
review?
here's the problem with the philosophy, okay? If you say products of nature can't be patent eligible, okay? Okay. What the court should have said is answer this, riddle me this, Supreme Court, 3 claims. Penicillin, a pharmaceutical composition of penicillin, or an isolated preparation of penicillin having some characteristic. I don't really care what it is. The first claim's never been patent eligible. Why? Because like vanadium and like other things, it's a product of nature. It is exactly reads on what's present in nature because it has no limitation except that it's penicillin. The second one, I hope, is still patent eligible because it's a pharmaceutical composition. It clearly has been taken from nature, changed by man, made into something useful. The question that the court kind of answered for DNA, but I'm not sure even then answered, is what about the third one? What about if you take, and in the Inouye-Berge case, which was the companion case of Chakrabarty, it was for a new antibiotic, lincomycin. And there was no question that an isolated preparation of this drug of this chemical, which could be made into a drug, was patent eligible. That even wasn't a question before the court. So now the question is, after Myriad, and the question we're all thinking about is, even though Myriad was limited on its facts to DNA and expressly limited to DNA, are you going to be able to take that the next time somebody goes and finds a tree somewhere that makes a molecule that can cure cancer, and are you going to say, sorry, it's a product of nature, you can't patent it?
So
I mean,
that was certainly much discussed.
Oh, yeah.
That was much
Members
discussed
of
by
the
the
court.
Supreme Court, but I don't
sure
see
it
it
was.
as a difficult problem. I mean, I see
What's
a
your
vast, there's a vast difference between taking something and manipulating it into a drug. I mean, you haven't explained how the extract.
Oh, no, I think the drug is fine, but I think that
No.
you may...
If you want to take an extract, if you want to answer Alito's question in the Supreme Court, which was sort of what you're getting
Sort
at,
of, yeah.
you haven't given an example of a chemical compound that has not been altered.
Taxol. Taxol is from a yew tree, it's from a leaf. All you do is extract it from the leaf, and that's many things. You just extract it out of the leaf. And it's, in fact, less altered than cloned DNA is.
Well, we're not
because you
talking about
changed it.
cloned DNA. We're
Well,
talking about isolated DNA.
Isolated is cloned, the way it's used. Isolated DNA does not, well, here's the problem. If you take the position that merely isolating the entire chromosomal DNA falls from the scope of the claim, that was anticipated by Michener in 1874. Okay, so that can't be the way you interpret the claim. And the way that the patent office has interpreted it, and the courts have interpreted it ever since biotechnology started, is you have actually taken out the DNA from the chromosome and have separated it from all the other DNA in the chromosome, and it's isolated. What I'm saying is that the chemical changes you make to do that are greater than, both qualitative and quantitatively, what you do to extract Taxol from a yew tree leaf.
Well, I don't know Taxol, so I'll have to defer to somebody
Assume
who
I'm
does. I don't think you are.
Well,
I mean,
assume I'm right
yeah.
technically. You can argue the law, but assume I'm correct technically. So what's the, how have you now said, I've said that as a policy matter, as a philosophical matter, merely isolating DNA in a way that you have to do, and if, granted the way you do it isn't important, but the amount of things you have to do is technically way more sophisticated and it affects a much greater change in the molecule than merely extracting a drug from a leaf. If now you've said that that's not patent eligible, then your drug's not patent eligible. Now, maybe we're saved because a pharmaceutical composition is. Maybe. Okay.
well, not just maybe.
I hope so.
I mean, that's a
That was
huge.
the intent that I got from the court. You're stuck on obviousness.
Well,
Once
I
you
mean,
just
you
said,
No.
okay,
I
take Taxol and
don't
put
think
it in
it's
phosphatic
I don't think it's just obviousness. I think the whole problem is maybe your statement. Maybe we're saved by the composition. Of course, you're saved by the composition.
I hope so. And if
Well,
we are,
well,
we're fine.
But
Then
also-
your argument has no
but
basis
also
at all.
I think that isolated DNA in this case was, in the plain sense, isolated DNA, and I think that many of the judges,
Well-
like Judge Lurie, really got into, I'm breaking
covalent bonds,
and
exactly.
now it's
See,
But of course, the
something
sad
different.
thing about all this is if I want to give you a claim to isolated genomic DNA that is should be patentable under the cDNA, it should be where it's in a vector in which there are heterologous sequences to allow expression of that DNA. And frankly, for most of the biotechnology industry, that's exactly how it's used. And that's the good thing. But in terms of did we actually stop people from isolating genomic DNA? Probably not. Now, the broadest claim, yeah, but there are plenty of other claims that are useful that you can get.
cDNA, though, in this case was really a stalking horse for recombinant DNA.
Yes.
And
the industry.
the significance in the industry, and the significance of it has really been, vastly overblown. And presumably, you guys aren't staying awake at night worrying that Chakrabarty was overturned.
That was my worry before the case. But yeah, that shows, as long as Chakrabarty wasn't overturned, we're good. And I think that's why Myriad stock went up right after the decision, and that's why the biotechnology industry didn't see a huge sell-off. I mean, I think that what biotechnology industry does on the therapeutic side is still fine.
But
Well, look,
why do you act like such Chicken Little?
well, let me just
because people like
say.
doing that.
Let me say. I mean, after 20 years of representing businesses larger than Myriad in patent cases, there's no way to estimate really what it did to their bottom line. But I know they paid their attorneys. I know Jones Day got a healthy sum of money for defending this case. And if this really had such inconsequential effects, I would assume they're very regretful about having brought the case and defended it.
Well, I'm regretful if they did, but the fact is that I heard a rumor that Jones Day did it pro bono. That's just a rumor, so I don't know if it's true or not.
Yeah. Well, you can.
Well, that's what I heard. And secondly, I just think they're an obstinate bunch. I think
Who,
that
Myriad or
yeah,
Jones Day?
You know, well,
Yeah.
but Myriad, I think that this was their patent right, damn it, and they were entitled to it. And I just, because I've spoken with those guys at meetings when and such, and said, what are you doing? If the ACLU wants to take every gene patent down one at a time, let them go to every district court and do it that way, and don't even appeal. But
They had such a big marketing advantage
Yeah.
that's going to carry over
That's
for
right.
them for the next couple of years.
well, and even afterwards, and frankly, they have the first mover advantage. They've been doing it for 15 years.
Exactly.
And their patents were going to expire in a year or two all the time. Anyway.
But then stretched out over.
Yeah, I mean, at the end of the day, they may have said, okay, we can put our stake in the ground here, but look what I have in my back pocket.
Well, yeah.
And
I
that's
don't-
what they're
I don't-
trotting out. That's basically what their general counsel said about 2 years ago, or 2 days ago.
Yeah,
But
2 days ago, yeah.
Kevin, I mean, based on what you said, and you've made a cottage industry out of the Myriad case, so I know you've got
Oh,
an
I've done
opinion
more than
about
that.
this. Do you then disagree with the U.S. Supreme Court's opinion?
I think, yeah, I do. Basically,
Okay.
I do. Yeah. I do.
And on what grounds?
I think that making the argument that changing shouldn't be enough, and that giving new use to things that occur in nature shouldn't be enough. I think that's wrong. I think that we'd be better off if we allow things to be freely patented, and then in cases where they were commercially important, they would succeed, and if not, not. I also think that the Supreme Court had a very easy path given to them by the Department of Justice to make this, sheep and goats. This isn't and this is, and everybody's happy. So the medical geneticists are happy because they're vindicated, and Myriad's happy because its business isn't hurt, and biotech industry is happy because we still have Chakraborty and we can still have cDNA, and so it was very much a split the baby in the best sense of that word.
Well, Myriad is, you can say Myriad's happy. Again, I would doubt that. But let me put it this
That's
way:
sad.
the cDNA,
Yeah.
the cDNA component was something that got interjected in the case rather late in the game, and I think for the very reason that you're articulating, it was a means of splitting the baby.
Yep.
I do not think there was a legitimate claim at issue that was a cDNA claim.
I think there was, but that's a
And-
factual dispute.
No, I think there was a claim.
There was.
And again, I personally disagreed with the attorneys in our promoting that claim. I thought it was fairly
leave that alone.
frivolous
Yeah.
in the debate. But I still think that there is a fundamental policy issue here, and I think there are good patents and bad patents. The fact that something can be patented doesn't necessarily make it
Good. And that's the ideology that was being corrected here, the presumption that if you can get a patent, it must prima facie, it must be a good thing. I mean, you can read it in the metabolite dissent.
Yeah, that's exactly right.
And the whole point here is that, your side of the case kept arguing about how complicated it was to identify these things. Irrelevant.
Well, I agree. I don't think the point is that we don't have gee, it was so tough I deserve a patent test. And I don't think we should have
That's the way Myriad argued the case.
Look, Jones, they didn't hire me. They hired Jones Day. What can I tell you? I mean, they did what they did, but they made the arguments they made, some of which, I mean, Seth Waxman, who has a lot more experience than I'll ever have in the Supreme Court, said at a meeting that he read the transcript of the oral argument, and as he said, quote, it was not for the faint of heart. And I will tell you, it was 12 people who really, in terms of the basis for it, wasn't really sure that they got the basis in the science or the patent law, but that wasn't the point. The point was to make this philosophical announcement, and that's fine, the Supreme Court does. If they did it 30 years ago, we have a lot less diagnostics, we have a lot less therapeutics, and we're in trouble. They did it now, gene patents are dead in about 5 to 6 years, because they were all filed in 1998 to 2000, they all have 20 years for filing, and they're pretty much all gone in that amount of time. So we've moved past the gene patenting era, we've moved past the technology for doing the testing. Because as I was talking to Dave yesterday, you can zip your whole genome in, for $1,000 or $2,000, whatever,
And do
then
the
go
whole
look.
genome for this for the price of a BRAC
Exactly,
test.
exactly, and then go look and see what
bit
you...
more, but still comparable to Myriad's test.
Right,
yeah.
so I mean, the problem, of course, Myriad has, as always you have, is the technology's passed them by. And so now, you know, I'm not sure that Ambry infringes their claim. And I think that's a very good question. If you have second, third, fourth generation testing, do you even infringe the claim? Does your fighter jet infringe the Wright brothers' claim to their airplane?
Right. Well, they actually talked about the method of sequencing.
Yeah, that's right.
And
In the
they
brief,
didn't, when they framed their claims, and they didn't anticipate that there were going to be new methods of sequencing. And
the crystal ball was not working that day.
but it seems to me that when you guys are writing claims, you always want to make them as broad as possible. And
Yeah, that's the bad patent.
No, you're right. You write a range of claims.
Yes.
And I think you'll see an example of that in Myriad's later application.
Yeah, and that's
they
what
said
they
the
did.
same thing 15 different ways with just enough difference in scope
Right.
so that it wasn't double. You know, it
Yeah, it's
wasn't
kind of
the same
like
claim.
if you go to the Art Institute, you know, you see the broad swaths, and then you see the puntalist painters. And patents are more like the puntalists. You do little prescribed things, and you try to make your picture out of that whole thing.
But I still think you're acting out of or you know, this may be overstating it, but there's an 80s, 90s, you know, ideology at work here that says, if I just word it properly, I can get it patented. I think the Supreme Court in Mayo was sick and tired of that.
Well, they don't pay attention to patent law. So,
They
you know,
do. I mean, that's another myth.
No, what-
That they
what's
got
gonna
it
happen?
wrong because they don't understand
No,
patent law.
I didn't say they didn't understand it. I said they really, look, the Mayo, if we're going to talk about Mayo, that's the pornography test. That's the I know it's patentable when I see it test. I don't think that's viable unless they want to become the patent court. I think that as it is, Mayo's more trouble than Myriad because it's a broader, there's more dicta. Justice Breyer wrote it instead of Justice Thomas. But even today, there are people scrivening back, hopefully in my office, who are trying to get patents to diagnostic and other methods that fall outside the scope of Mayo.
Well, I'm sure they're back there scurrying away. Just, but you know, the whole point.
The next case, Mayo case, will be one of these.
That's right. That's
Cases.
right. And that will percolate up.
But that's not a bad thing. I mean, why?
No.
I mean, your complaints on the other side are always, well, everything's a product of nature. How do we know where to stop? But the test is no clearer than the test for obviousness. A person of ordinary skill in the art.
Yeah.
Okay. Well, I mean, yes, it's a pornography test, but so is almost every one of the tests you now live by.
There are a little bit more analytical framework to obviousness
No,
than
there really
that.
isn't.
Well, I think
Well,
there are.
there's a little more to it, but whether it's actually any more definitive is another question.
I think you're right about that. It's,
Yeah, that,
I mean,
it could-
you look for the
it could be-
suggestion,
yeah,
et cetera, but
Yeah, but what is that? That's
Yeah,
a
that's
way
right.
of getting around indeterminacy by
That's
just
right.
creating more
But
standards.
there's one distinction I think we have to make, and that is with obviousness, that is specific, whereas 101 is categorical. That is, you don't even get in the door, okay? You can argue in 103, and in fact, you look at what Justice Breyer said in Mayo about 103 and 102, that gets too complicated. We got to figure out whether it's patent eligible at a categorical stage and not even get to whether, in light of the prior art, would it have been obvious, would it have been novel, we don't even get there.
But the justification for that is that certain things do not incentivize, which is the underlying purpose of the patent.
Right, and I think that yes, claiming a law of nature broadly, as Myriad did with the comparing, too broadly. But you look at a lot of claims like the ones that Myriad are advancing now against these, maybe they are narrow enough and specific enough that they do help commercialize, not incentivize.
That's
But they-
possible.
right.
That's
We'll see.
possible.
We'll see.
okay, I'm going to have to
Stop all
give
this
the
fun.
audience a few minutes for questions here. We have about 4 or 5 minutes left.
So you got towards this at the end. I'm curious as to how people think Mayo and this case are going to intersect, right? Because when I think about the cDNA issue, which I think Kevin is right to say gave the biotech industry lots of comfort that this isn't going to go so broadly, it turns out to be, I think, trivial as a matter of biotechnology to create cDNA from natural products. And we would say, the court, I think, would have to say messenger RNA not patentable. right? Create the mirror image of it with cDNA. Now we say that's a man-made thing. I see no way to square that with the language in Mayo that says you don't get a patent merely by taking something that is otherwise unpatentable and adding conventional ordinary steps to it. We need something new. So I guess the question is, what happens when we put those two into conflict, whether it's in Myriad asserting cDNA claims in subsequent litigation or something else? Does the court back off of Mayo and say, never mind, we didn't mean it, or are the cDNA type claims invalid?
I don't think that's going to happen, though, because cDNA isn't covered. cDNA isn't economically important for most genetic testing, and it's not important for most recombinant products. So it's sort of hanging out there. I share the same concerns that you have as well. And further complicating, the issue is that cDNA does exist in nature. The court chose to ignore that in their opinion.
So I agree with that. Although, so then change the hypothetical a little bit. Change it to one of Myriad's claims to a DNA sequence with a primer attached to it. Turns out that if you actually want to sequence any of this stuff, they're pretty much all going to have primers attached to them.
So
but it's now no longer a naturally occurring thing.
Right.
And
so that's being challenged in Ambry. I was reading the claims in Ambry yesterday, and they do exactly that. And so we'll see how.
So I think the issue you're getting at is that Prometheus really, highlighted the difficulty of how much change is enough change, how many added steps are enough added steps. They made it a more or less a quantitative analysis. Which bothers a lot of people. You hear it's the same definition of pornography. I know it when I see it. But I mean, I don't think that it's going to be any more difficult than any decisions on invalidity. I mean, because, other than anticipation perhaps, because you're still always going to be confronted with degrees. And I think what Prometheus stood for was looking at what Judge Lurie did in the Federal Circuit. They simply, in Myriad, they simply said, look, we do not think that the change you identified is enough. That is what we said in Prometheus. We said it about a process in Prometheus. You said it didn't matter because it was a process, not a product. We disagree. We were merely talking about what constitutes sufficient transformation. It's never going to be a necessary and sufficient condition test. But I will say this, that the thing that I think, for example, Judge Moore and a lot of people miss in the context of products of nature as opposed to processes, everybody's looking at Chakrabarty because the test is, are the products sufficiently different? Are the characteristics markedly different?
Hand of man,
And
markedly different.
how do you determine that? Well, I don't know, but a lot of standards are that vague. So the real test is, are the new utility claimed, in this case, for example, if you look at a vector, and I think cDNA fails to be patentable for this reason, is the new utility claimed for the product related to any human innovation? And that's where Judge Moore got it wrong, because she said, well, you've got a new use for it, and they're a little shorter, But the problem is that the new use was predominantly a natural characteristic of the DNA, that it bound to something. So the test has to be not is there human intervention and is the difference enough? It has to be, are the differences related to the human intervention? And that's what the Supreme Court did, I think, in Myriad. They said, yeah, there's a little human intervention here, isolating, but it's not enough to make a sufficient change because the whole purpose of this is to use it as it was intended by nature.
Okay.
We could quibble about that, but I won't. We're done.
I just got the signal that we're done. We can finish this at Dillon's after the symposium this afternoon at the bar.
Thank you. Very nice. Thanks.
Thank you.
So we'll take.